Now, without further delay, I would like to turn today's presentation over to Gary Bossert. Gary, you have the floor.
Great. Thank you, Alicia. I appreciate that. And thank you for everybody on the call today. I think you'll find this presentation very interesting. This is one of a quarterly series of webinars that we present to NCMS plan practices on employment law topics. We select topics not specifically related to employee benefits, yet topics that we believe are relevant to your work every day. I know that many of you fill different roles in your practice and titles can vary, but one thing I'm sure you have in common is that you have some responsibility for the management of your staff in your practice and the employee relations issues that inevitably come up. As a practice manager, a supervisor, or an HR professional, you probably treat your company's employee handbook as a sacred text. And if you don't, you probably should. While you won't find answers to life's deepest mysteries in an employee handbook, you will find answers to many of the questions your employees most frequently ask of you. Things like, what do I need to do if I call in sick? What exactly do you mean by office-appropriate attire? Or how many vacation days do I get every year? For most employees, however, their employee handbook is just another stack of paperwork that they're handed on their first day. They skim through it a few times that first week, but are unlikely to even think about the handbook again until they are found to have violated one of the policies it contains. So why do practices even bother to put together handbooks that employees may or may not bother to read? Because the policies contained in a handbook act as a practice's first line of defense against lawsuits or liability claims. In short, employee handbooks can protect employers and their employees. Even if your employees don't treat their employee handbook with the reverence that it may deserve, the protection that it provides both your practice and its employees are vital to ensuring the longevity of your business. We are fortunate to have Ariel Harris and Lauren Nations from the law firm Nelson Mullins with us today to discuss how practices should create and update handbooks and policies to better protect you from liability risks. Ariel Harris is a member of Nelson Mullins' litigation group and the labor and employment practice. She focuses primarily on business litigation, which includes complex commercial disputes, employment law, and financial services matters. Additionally, her practice covers a range of industries in the drafting and enforcement of non-compete, non-disclosure, and confidentiality and other employment-related agreements. She has represented clients in both the negotiation and drafting of relevant agreements and the regular enforcement in litigation of the claims of employers seeking to enforce those agreements. Lauren Nations is a member of Nelson Mullins' tax and benefits team and assists clients with all types of employee benefits, executive compensation, and employment law matters. Prior to earning her law degree, Lauren worked as an HR professional, which allows her to better understand the challenges faced by clients in dealing with employment and benefits issues. Thank you, Ariel and Lauren. The floor is yours.
Thank you, Gary. Hello, everyone. Ariel and I are excited to be here, and hopefully we can give you some information about your policies and your handbooks that you will be able to use. Like Gary said, you don't often appreciate your employee handbook until you're later faced with an employee coming to you and saying, well, I didn't know about that policy. And you want to be able to have an effective handbook that you can point to that you have provided them to show that they should have known, which will protect you against liability. As an overview of what we'll discuss today, going to go over some policies that you should include in your handbook. We may not be able to cover every single policy that should go in your handbook, but the ones we'll talk about today will be some of the most important ones that you should make sure to include. We're also going to include some recent updates in the law on particular policies. And I was going to share a quote that I found when I was preparing for this presentation, that a company without an employee handbook is like a sandwich without bread holding it together. So it does help bring everything together. Before we get into why, what needs to go in these particular policies, I always like to talk about why should we care? Why is it important for us to make sure our handbooks are the best that they can be? And as you are probably aware, the EEOC is more active than ever. They filed 220 actions last year. 200 of those were lawsuits on behalf of employers that, or against employers that they felt had violated employment laws. To give you an idea, I know many of you are in North Carolina. The Charlotte office had 16 of those lawsuits, and just to compare, the New York office filed 16 also. That's you wouldn't think that that's a lot, but when it ties with one of the larger cities in the nation, that's interesting. The greatest filings were in Chicago, which had 21. So the Charlotte area is pretty active. And again, as you can see, most of those cases filed were regarding Title VII, which protects equal employment opportunity. So another reason why you should care, you want your policies to be effective to help you stay off of the Employment Opportunity Commission and Plaintiffs' Counsel's radar. Basically, it will help you clarify what's appropriate and inappropriate in your workplace, emphasize that the company does not tolerate retaliation or any other equal employment violations, and you want to provide reporting channels for them to report inappropriate activity. And with that, I'll toss it over to Ariel, who's going to talk about the handbook introduction.
So as was mentioned, the employee handbook really is one of the most important communication tools between a company and its employees. You want to make sure that your handbook is up to date, that it properly addresses policies, and it adheres to federal, state, and local laws that are applicable to your company. One thing I'll say is some of the vital times that you want to kind of reassess and make sure your handbook is up to date are when governmental administrations change. You always want to just kind of revisit and make sure that you're paying attention to different laws that might change, different ways in which implementation of the laws change. Specifically in North Carolina, I'll give an example. The North Carolina Supreme Court has historically been either split evenly or more heavily. The bench has been on the Republican side, but here recently there are 6 Democrats and 1 Republican on the Supreme Court bench, and so it will behoove you to just stay aware of any case law that might come out in which it would affect your company. So the theme here today is just to make sure that anything that is written in your handbooks, you follow that policy, because that's really your first line of defense. As Lauren said, handbooks help in litigation environments. So your first line of defense is that you have policies and you follow them. With regard to personal introductions in a handbook, you want to include these personal introductions, and you want to make sure that they reflect your company's unique culture, just by tailoring it to maybe your industry or the size of your company, and again, specific laws that uniquely affect you. It's an exciting time for employees when they onboard to your company, and so the handbook really is an essential tool that really sets the tone for employees. You may also consider including a mission statement or maybe a sincere note from the president or CEO, just kind of, again, providing that sense of the company's culture in the handbook. When including at-will employment statement in your handbook or policy, you just want to make sure, first know that North Carolina is an at-will state, which means that an employee can be fired or leave the company at any time and for any reason, so long as that reason isn't unlawful, like discrimination. The at-will policy should be clearly stated. It should be conspicuous, and I would recommend always having that statement somewhere in the front of the handbook, somewhere toward the front. You want to remind your employees that the handbook is neither a contract of employment and that their employment is, if you intend for that employment to be at will, you want to make sure that it's clear that employment is at will. And as the statement says and correctly defines, employment at will means. So you want to make sure it's clear what it means.
Talking now about some workplace behavior policies that you want to include in your handbook. Usually at the forefront, you reference the company's equal employment opportunity or EEO policy regarding anti-discrimination. And I'm sure many of you are familiar with, Title VII protects against race, color, religion, gender. Age is protected by the Age Discrimination Employment Act. national origin, disability, and veteran status. What we included on this slide is some additional information on whether sexual orientation and gender identification are protected, because we get a lot of questions from our employers, do I need to include that category in the list of things that are protected? And that's something that, is in a lot of transition right now. Everyone's watching as to whether the Supreme Court will take up that issue for the nation, because there's different stances from different agencies. The EEOC says, yes, it is protected. The Department of Justice says it's not. And then there's a circuit split in different jurisdictions as to whether it's protected or not. So I'm in Georgia. The 11th Circuit says that it's not. I think North Carolina, they're in the 4th Circuit. They follow the 5th Circuit saying that it's not. But there's certain recent circuits have found that it is. So depending on where your office operates, that you need to follow the circuit in your area. What we basically, or what we generally recommend to our employers is to just include the catch-all after you mention those categories at the first bullet point, include or any other legally protected status. That'll help you just to have everything protected that is protected at that time under the law. It's covered. So a lot of things that have also got, or something that has also recently gotten a lot of attention is sexual harassment in the news with the Me Too movement. So you want to include an anti-harassment policy. You'll want to include that it applies to vendors and clients who interact with company personnel, and also maybe include a non-exhaustive list of what constitutes supervisors have a responsibility for keeping it free of harassment. And to help with that, you'll want to designate a complaint procedure. You can either mention someone in the HR office who will be responsible for taking those complaints, or use an anonymous hotline. And of course, if you're going to be using someone in the company to take those complaints, you'll need to provide an alternative in case that person is the alleged harasser. So in speaking about internal investigations into this type of behavior, one thing that often comes up is, employees want to make confidential complaints. They don't want to draw attention to themselves or whatever, for whatever reason. And that's actually something you shouldn't say, that you will keep it confidential, that it will be determined on a case-by-case basis. The National Labor Relations Board actually took up this issue with a policy, and we provided a sample policy there that you can use, that they have okayed, regarding confidentiality of internal investigations. And in that respect, too, with the anti-retaliation policy, you'll want to include that. But mention that they'll only be protected if they bring the practice to the company's attention. And that's important because you can't be responsible as an employer for what you don't know. So you want to make sure they know they need to let someone know what's going on. We've also included a sample policy there that regarding anti-retaliation. And that you you want to let them know that you'll investigate the complaint and will take disciplinary action as appropriate. Also, you'll want to include the company code of conduct. This will mainly address broad issues such as workplace violence, could also include dress code, what's appropriate behavior at work. So again, earlier when you mentioned what wasn't appropriate behavior, that's similar to a code of conduct. And you also want to let them know in this section that when they use company equipment such as email and voicemail or internet use, that they shouldn't expect any right of privacy in that use, and that you may monitor where they, what they send with their emails and where they go. You also want to include in your handbook a discipline policy, and it's up to your company as to whether you want that to be, to include progressive discipline, such as verbal warning, written warning, suspension, and termination. Not every company wants to have a progressive discipline policy, but some choose to do that, with their employees. But you want to be careful to use language that will imply that you will use progressive discipline or every single stage of it every time. So we've got a sample policy here that gives the employer discretion as to whether they want to use the progressive discipline and allows them to advance to certain stages of it in their discretion. That way an employee can't come back that the first time they get in trouble and you say, look, I have to let you go, you're terminated, and they say, well, I never got a written warning or I never got a verbal warning. You want to be able to point to the policy saying they were aware that you didn't have to follow those steps in every single situation. We'll talk briefly about drug testing, mainly because we discussed a drug testing policy. If you were able to join Anne Murray and I for our NCMS webinar in December, we talked about drug testing policies. Just some particular things you'll want that policy to include. You'll want to prohibit using drugs as well as possessing paraphernalia while at work, and clearly state that they are subject to discipline or discharge if they're under the influence of drugs or alcohol during work time. You also want to let them know you'll respect their privacy and keep the drug test results confidential. Also, as part of your drug testing policy, you'll definitely want to specify when they could be tested so that they are aware. So, for example, sometimes employers will do this pre-hire, upon an accident, situations like that. You'll want to put those in your employee handbook. Especially in regards to random drug testing, you'll need to let them know that they could be subject to a drug test randomly. And also state whether it takes only one supervisor or several managers plus the HR department to decide to require the employee to take a medical test. And with that, I'll toss it back over to Ariel regarding HIPAA, which I think is particularly important to many of you guys.
Yes, specifically for this industry. So the one thing I'll say is, as attorneys, Lauren and I, confidentiality is the cornerstone of our field. Ensuring that clients trust us with their information is key in maintaining relationships and building our practice. And the same rings true for the healthcare industry. Patients entrust you with sensitive information, and they want to make sure that that information is protected. And so HIPAA is very, very important to your industry for that reason. I've included HIPAA definitions just so it's clear what covered entity means, and specifically with disclosure that it can include verbal disclosure, inadvertent disclosure if you've left some PHI on your desk inadvertently. Say, for instance, you're a receptionist at a healthcare provider location and you leave information on your desk. So disclosure can come in a variety of ways. Your handbook should state that confidentiality of employee protected information and client or patient protected information is required. It should also clearly state that there can be disciplinary actions taken if there's a violation that occurs, up to and including termination. In your handbook, you don't want to box yourself in. As Lauren stated, each instance of that necessitates some disciplinary action should be handled on a case-by-case basis. And so your handbook should state that. So any alleged violation of HIPAA will be investigated. Your handbook should state that. It will be investigated. However, all instances will be handled on a case-by-case basis. Lastly, the handbook should clearly state where a suspected HIPAA violation can be reported. And it should also give alternatives again. So if the person that is identified in your handbook is a supervisor or a manager, there should be an alternative if that is the person who is, suspected as the alleged HIPAA violator. I've also included a list of certain violations, and again, you want to make sure in your handbook, if you do list a non-exhaustive list of violations, that it is specifically stated that this is a non-exhaustive list. These are just examples. They include but are not limited to that type of language, so that your employees have expectations and they understand that they understand what constitutes a violation, but they also know that the specific violations listed aren't the exhaustive list. And so I gave one example that kind of has popped up in the current events is, I don't know if you guys have been keeping up with the Jussie Smollett case that has occurred in Chicago, but it was recently reported that approximately 60 or so healthcare personnel were fired, or some disciplinary action was taken, and I believe the hospital is Northwestern Memorial Hospital. Some disciplinary action was taken because the employees inappropriately accessed his information. Now, he's a well-known actor, but that he still should be afforded the same privacy as anyone else. So just because it's a current event and it's an event that has garnered some attention, he still should be afforded that same privacy respect. And this event basically highlights that you as an employer should take your policies seriously. You want to follow them. Again, the theme of today is, if it's written in your handbook, you want to make sure that you follow your policy. Lastly, with regard to privacy laws, just remember that federal HIPAA law preempts state law. And it preempts state law because generally HIPAA laws are more stringent, but in the event that a state law is more stringent and provides more protections than HIPAA, then the state law would apply. But for North Carolina in general, HIPAA laws are in effect, and as an employer with PHI information, you want to make sure that you are very careful. And with that, I'll turn it back over to Lauren.
Thanks, Ariel. So another important section of your handbook should cover wages. And you'll generally see those where there's a section for employee classification. I'm sure most of you are aware that employees fall into two categories. They're either exempt or non-exempt from overtime. And as you know, non-exempt employees, they receive 1.5 times their hourly rate for all time they work over 40 hours in a week. What you'll want to mention in your policy here is that calculation for overtime, those 40 hours, is based on the number of hours they work and not the number of hours they're paid. Because employees often misunderstand that if they had some PTO hours in their pay that week that may have put them over 40, that they may think they were entitled to overtime. But it's only if they actually worked 40 hours, over 40 hours that week, did they get overtime. So you'll want to let them know that. Most importantly, in this policy, you'll want to make sure they are aware they're not permitted to work overtime without supervisor permission or off the clock. I've actually been involved with a claim, several lawsuits where the employees, they worked off the clock and they then later came back and sued for not only minimum or overtime, unpaid overtime, but also minimum wage, because they alleged that they weren't, when you calculated in the number of hours they worked that week, it took them below the minimum wage for each hour that they worked. And those claims can get really expensive. The FLSA provides for attorney's fees as well as double damages. You really want to make sure they're aware that they're not supposed to work off the clock. You do need to let them know if they work off the clock that they'll be compensated for that time, because again, you have to pay them for the hours that they work, but they'll be subject to discipline for violating your policy regarding off-the-clock work. So we mentioned we would provide you with some updates on recent changes in the law. You may be aware that the Department of Labor has recently, a couple weeks ago, proposed a new rule to increase the salary requirements regarding exempt employees. And again, you may be aware that exempt employees, to qualify as exempt from overtime, you have to satisfy a duties test, which means your job has reached a level of sophistication to where the duties are higher than what would be provided for a non-exempt employee, but also a salary requirement, and that's that you have to meet a certain salary threshold to be able to be classified as exempt. You may remember a couple of years ago the Department of Labor had proposed increasing this amount, and that was actually later enjoined by a court in Texas saying that they had improperly tried to do that. So recently they have revised some of their rule, and a final rule is anticipated to be issued in January of 2020. So you'll definitely want to keep that on your radar, and you can always touch base with Ariel and me to find out what the latest is on that. But that would increase the minimum salary requirements from $455 per week to $679 per week. I'll toss it back to Ariel to talk about the North Carolina laws on wage deduction.
So compensation is always important to employees. When an employee suspects issues with their pay, they immediately want answers, and understandably so. And so the handbook should set forth particularly where to go if there's an issue with or suspected issue with compensation. And it should also set forth just in clear and conspicuous language that the handbook is the first step in the process if there's some issue with wages and compensation. Wage deductions in North Carolina are pretty straightforward and laid out what can be deducted and how it can be deducted. The North Carolina General Statutes, Chapter 95, sets forth all of the ways in which wages can be deducted and how to go about doing so. And so you don't need to list out all of these, all of the ways an employer may withhold wages in your handbook, but you just want to be aware that Chapter 95 is where you go. But in your handbook, you just want to state pretty clearly that the handbook, although does not set forth all of the specific ways wages can be deducted, that the employer is committed to adhering to all applicable federal, state, and local laws related to wage deductions. So that's really the important thing. The first thing is the employer is committed to following the law, and the employer has provided somewhere to go, some supervisor, manager to go to if in the event that there's issues with compensation or wage deductions. You can go forward. So leaves of absence, time away from work for whatever reason is important to employees and employers. Time off may not always be planned. Sometimes it is planned, sometimes it isn't, and sometimes the need just arises unexpectedly. And so the handbook should, although not be specific, should give some detail as to what policies are in place with regard to different forms of leaves of absence. It's important that the employer balances the needs of the employee with the potential impact that the time off will have to the company. So the leave policies should be clear in the handbook. With regard to vacation leave, in North Carolina, private employers aren't required to provide employees with vacation benefits, but again, the quality of life and the quality that you want for your employees when they are engaged in work, you want them to be productive, you want them to be happy, and so, vacation leave is generally applied and given by most employers. And so really the rule of thumb in North Carolina, because it's not required by private employers, is that if you have a policy and if it is in the handbook, and it should be not in detail, but you should give information with regard to how and when vacation is earned, whether or not vacation time can be carried forward from one year to another, if it's, what the policy is on rollover, if there are times that vacation must be taken, when, whether vacation pay may be paid in lieu of time off, and the conditions by which vacation pay will be forfeited. So those are kind of the key areas that should be addressed in your handbook. But the biggest thing is, whatever is in your handbook, you want to make sure that you're following that policy. With regard to holiday leave, it's essentially the same thing. Private employers are not, they do not have to have a holiday leave policy, but again, you want your employees' quality of life to be that in which they are able to enjoy their family and friends on specific holidays. And so if you do have some type of policy in place, again, you want to make sure that you are adhering to that policy, and that's always the rule of thumb. If it's written down in the handbook, make sure that you follow it. And I've also listed for state entities, those that are governed by our state government, there are specific holidays that are observed. And so, again, in the policy, you want to list out those holidays and be sure that it's clear which holidays are observed by your company.
And just to add to what Ariel was saying about following your policy, I mean, that's so important, not just to protect against an employee saying, well, you applied that policy against me and you didn't apply it against the other person and you were discriminating against me because of that. But it'll also protect you. I know here in Georgia, I'm not sure if it's the same in North Carolina, maybe Ariel, you would know, but they recognize a breach of contract claim if you have a promise that you make in your employee handbook and then you don't actually do that, what you said you would do. A case I was involved in, the policy said that they would pay out PTO upon an employee's termination, and the employer didn't. So one of the first things we got from the plaintiff's counsel was a request for our employee handbook, and then she had testified in her deposition that she wasn't given that PTO payout, and again, she had a state law breach of contract claim based on a promise made in the employee handbook. So you want to make sure your policies are good, and then you want to always follow those to where, unless your policy says you have discretion not to do so. But yeah, you always need to make sure you follow your policy.
And I'll just add to that, I don't believe North Carolina recognizes a breach of contract claim with regard to handbooks.
Okay. Lucky you guys. For FMLA leave, I know many of you are on the call or on the webinar are familiar with the provisions of the FMLA. Basically, if you have 50 or more employees, an employee who has worked for 12 months and completed at least 1,250 hours of service in the past year, they are allowed to take 12 work weeks of unpaid job protected leave or 26 weeks for leave taken to care for a covered service member. What I often find here by a lot of employees that obviously haven't read a handbook or know much about employment law, they're always surprised sometimes when they go to take leave that the leave is unpaid. So always make sure to highlight that in your policy that the leave is unpaid but that their job is protected. And again, they're allowed to take that leave for their own serious health condition, care of a newborn during the first 12 months following birth, care of an adopted or foster child during the first 12 months following placement, care of a child with a serious health condition or a spouse or parent with a serious health condition, or a qualifying exigency arising from their spouses, sons, daughters, or parents qualifying active duty in the armed forces. One thing you'll need to indicate in your policy is whether PTO, paid time off, will accrue and whether holidays will be paid. You're not required to do that, to actually continue to accrue their PTO or provide paid holidays because they're not working. Some companies choose to give that to their employees as just a employee morale thing to do. But you'll want to indicate whether you will do that or whether you won't. You'll also need to indicate whether that FMLA leave will run concurrently with paid leave. So we often see a lot of policies that the company requires them to exhaust their vacation bank as they're on that unpaid leave. So you'll want to specify that in your policy. Also important, you need to, if you're going to require them to take a fitness for duty test prior to coming back to work, you have to give them notice of that in the handbook. Another important policy for your handbook is something regarding the Americans with Disabilities Act, whether you regarding your accommodation process, particularly because most employees and even some employers aren't aware that the process for obtaining or requesting a reasonable accommodation starts with the employee. So in the beginning of that policy, you'll want to restate the company's equal opportunity and non-discrimination policy, and then inform them that if because of a mental or physical disability they need an accommodation to enable them to perform the essential functions of their job, they need to notify their supervisor so that you can engage in the dialogue to determine how you can help. And again, you want to use important language here that, a lot of these phrases like the essential functions of your job, those come from the ADA. And most importantly, you don't want to say how we may be able to help, not that you necessarily will be able to give them the accommodation they request, because, the ADA only requires a reasonable accommodation, and that is determined by whether the accommodation will impose an undue hardship on the company. And that, of course, is determined by the company's resources and the particular job in question. So important in your handbook is also a section regarding workplace communications. I think many of you are familiar with the National Labor Relations Act. Many employers, though, wrongfully think that just applies to a unionized workforce, which you don't see many of anymore. But it also applies in part to non-unionized workforce, and that's in regards to Section 7, which gives employees the right to engage in what the NLRB refers to as concerted activities. So they're joining together for mutual aid or protection. So they're joining together to help make the workplace better. The employers are prohibited from doing things that would tend to chill, as they refer to it, their exercise of joining together to mutually aid each other. So some specific things, what the NLRB will look at is if the policy explicitly restricts activities that are protected by Section 7, it's unlawful, just like that. But then it could also be construed, or it could also be unlawful if that policy could either be construed to prohibit their exercise of those rights, or was issued in response to protected activity, or was applied to restrict the exercise of those rights. So now we'll talk about specific ways that those policies could be found to be unlawful. So your handbooks probably include, or should include, a non-solicitation policy, and that's not, we're talking about solicitation of clients when they leave, or solicitation of employees after they leave. This is regarding if while they're an employee, they want to talk to other employees about forming a union, for example. You can only prohibit solicitation and distribution of literature during work time and in working areas. So obviously, break periods and meal times aren't generally considered working time, and working areas would be everything at the work site except for break and lunch rooms and parking areas. Your handbook should also have a bulletin board policy, but again, just make sure to pay attention to any restrictions that may come or from the NLRA. You can restrict them for business use only and limit the personal postings to defined categories, just as long as you consistently enforce that distinction. So, for example, if you say, we won't allow anyone to post, organizations that are affiliated with a church, but then you let someone, have a posting regarding just a little civic club. It's like you need to be consistent in how you, in what you prohibit on those postings. And then just make sure you consistently enforce that. With that, I'll turn it back over to Ariel for the employee's use of the employer's equipment.
Thanks, Lauren. With regard to employees' use of employer's equipment, you just want to make sure that it's clear and employees understand and understand your expectations about your employer equipment, and that it's the employer's property and it's intended for business use. You also want to make sure that employees understand and employers understand that the reality of the situation is there will be times where there will be some limited use for personal purposes. And in the handbook, it should just state that although the equipment is the employer's property, that employee may be permitted at some point to use it for limited purposes, limited personal purposes. Or if you want to eliminate personal purposes altogether, I wouldn't suggest that just because it's not really realistic, but again, always stating it in the policy is important. With regard to employee use of employer's equipment, you should always reserve the right in your handbook to inspect all company equipment. Because it's the company's equipment, again, there are certain times where it's appropriate for companies to have access to that equipment. With regard to legal purposes, for instance, if someone brings suit against the company and the employee, a specific employee is implicated in that suit, their equipment might be important and relevant to that suit. And so, again, employees should understand that it's not their equipment, it's the employer's equipment. Also in the handbook, there should be a policy for the return of company property. Should the employee discontinue their discontinue their employment with the employer. In that policy, it should be clear who the property should be returned to and maybe a time period in which that property should be returned. So the last handbook that I drafted for one of our clients, basically, here's an example, and here's what it stated. Any property issued to you, including but not limited to XYZ, must be returned at the time of discontinuation of employment. Employees are responsible for any loss or damaged items issued at the time of employment and for the purpose of using during the scope of employment. The value of the property issued and not returned may be deducted from paycheck and may be required to, and the employee may be required to sign a wage deduction authorization form for this purpose. And so that kind of covers it all. The employee must return property and the employee now has the expectation that any property that is not returned may be subject to last paycheck wage deductions.
I would also add that the employees need to be aware that your discrimination or your anti-harassment policies apply during their use of your equipment, so that way they're on notice that don't use our company email system to send harassing emails to each other. They should know that, but again, it's good to include that in that section of the policy too.
That's a good point, Lauren. Oh, with regard to confidentiality policy, so within the handbook there should be that policy. Many employers have a policy prohibiting employees from discussing or disclosing confidential information. That includes compensation and performance appraisals, but you can't discourage your employees or prohibit your employees from discussing wages, hours, or work conditions.
We find that this one's often hard for our employers to digest because they want to maintain just the good, where people are at the workforce, they're getting along with everyone. But if you know what someone else is making, it's often hard for you not to feel unfair whenever you don't get the salary increase that they do. So it's often hard. We often see these policies where employees aren't allowed to talk about what they make. But again, you just have to kind of balance that with the risk that the NLRB is going to find that policy to be unlawful, unfortunately.
Correct. And with regard to confidentiality, in the employee handbook, you probably want to just make your employees aware that in most instances there's a confidentiality agreement. And so within the handbook, if that's applicable to you, if you do have such an agreement, you want to make sure that in the handbook it states that they would be expected to sign that confidentiality agreement.
That's a good point. And also, too, we often see a separate, like she said, a separate confidentiality agreement. And we do recommend that things like confidentiality agreements and any kind of restrictive covenants you may want them to abide by while they're employed be separate from your employee handbook. We sometimes see those included in their employee handbook. And the reason why we recommend a separate agreement for that is because, as we mentioned earlier, one thing you say in your handbook is, nothing in this handbook should be construed to be a contract of employment. But if you're later then requiring them to agree to certain things, you want that to be a contract of employment. So you do need to have those agreements separate.
Correct. So within the handbook with regard to confidentiality too, it should clearly state that employees are, and this will also be, and just as a side, this will also be in the confidentiality agreement, but I believe in your handbook you should have some kind of overarching language that employees are prohibited from removing or making copies of any confidential information that the company has. So that's the general policy, and then there might be some separate confidentiality agreement. You also want to let your employees know that disclosure of confidential information could lead to disciplinary action up to and including termination. So that should be included in your handbook. With regard to social media, I mean, we're in a social media age, and it's really easy for anyone to go to the internet with their grievances, with their frustrations, and so you just want to be aware of and understand what you can and can't do with regard to social media. Blogging, social media, and internet posting policies are often overly broad, and I've found this in many instances with regard to helping employers refine their handbooks. You can't just generally prohibit employees from making disparaging remarks about the company or depicting the company in a way in any way over the internet without company permission. You can't prohibit that because we all have a right to and we all should be able to air our grievances if need be. But I think one thing that you can kind of do to combat against that in suggestions that I've given to employers is encourage employees to make suggestions within the company in ways in which they don't feel as if their suggestions will diminish their employment in any way. It might be anonymous suggestions. Just let your employees know that you value their voice and their opinions. And so in the last policy that I drafted, there was a suggestions section in which it encouraged employees when they have suggestions in ways in which to make the company better that they feel comfortable and have open communication with the employer. Things that you can do is prohibit the sharing of trade secrets and employee contact information on social media. You can require those who identify as company employees in the post to state explicitly that their views and the views that they've expressed are their own and not those of the company. And reserve the right to monitor posts and comments about the company within your handbook. Just again, the employees should understand that there's no expectation of privacy while using company equipment. And so in the handbook, that should be included if there's a social media section.
The last thing we'll talk about is just something you're probably all familiar with is if you want to obtain an acknowledgement from your employees after you've disseminated the handbook that they have read it and understand all the rules and agree to abide by them, and you'll want to keep that acknowledgement in their personnel file. Again, as we mentioned at the start of the call, you want to be able to point to something that shows, look, you were aware of our harassment policy and you didn't abide by it, or you were aware of our complaint procedure and you never let us know, that there was a problem and how are we supposed to fix it. You want to have something to point to show that they were aware of what their obligations are. In that handbook acknowledgement, you've probably seen several of these before, but not only do you want to put in that by their signature they acknowledge that they've read and received it, but you want to include, again, that nothing in the handbook is intended to alter the at-will employment relationship. We just believe you can't remind employees of that enough, that there's no contract of employment. And also that remind them that the company has the right to modify or even suspend certain policies at any time. One question that often comes up here is whether you should put with or without notice, and that's more of a business decision, mainly because there's pros and cons to each one. If you want to say that you'll do it without notice, that gives the company the right to not have to notify its employees suddenly that it's changing its policy. But then you have to think, what is the purpose of having a handbook? What we said earlier, that way your employees are aware of what their responsibilities are and what their rights are. So do you not want to have them aware of what their, especially in regards to the code of conduct and things like that, of what those responsibilities are? So just think about whether you want to change certain policies without notifying them. In my practice, I generally recommend you don't include without notice, just because you want to notify them of what your policies are. And in that respect, anytime that you change your handbook or change a particular policy, we recommend getting a new acknowledgement, like issuing that new handbook to your employees. Many companies do it electronically via email or post it on their intranet, whatever your resources may allow you to do, and obtain a new acknowledgement with a new date, just because that way you can again point to, well, they received the updated policy. When I was in HR, I was often involved with doing an audit of our employee handbook acknowledgments to see, making sure everyone that was working for us at the time had not only had read the handbook, and also had read the most recent one. So that may be worth it to do in your practice if it's not super large, to where you could just make sure you have those acknowledgments from all your employees.
Lauren, that's an excellent suggestion. I've found in working with some of my clients that that's a sore spot for a lot of my clients, and really I counsel them quite often to just make sure that if there's any type of new version of the handbook, that employees are aware and they acknowledge that they've been given that new version.
And it may seem like it's something that's not worth the time to do that, to go audit that. But again, just you always want to be thinking not if a litigation occurs, but when. Like what do I need to do to protect the company as best I can? And that's one thing you can do that will help. But at that point, I think we have some time to take some questions if there are any. Gary, did you receive any questions?
Yeah, I have two questions. The first one goes back to something I think it was part of the earlier part of the presentation. It was about harassment provisions. So the question was about what is the practice's responsibility for within the handbook protecting employees from harassment from patients. You had mentioned vendors, I believe. So is there, and maybe customers is another way to phrase that. But how would they address that in the handbook?
I think that you would just include that it implies, like just use the language that's appropriate for your company. So like you said, patients would be something to include in that language, that it extends to them, mainly because, and Ariel, you can answer this too, employers have an obligation to provide a safe workforce. So the buck ultimately stops with the company and what the company allows to continue. So once the company is on notice that there's a patient that is harassing someone, I think just like when there's vendors of a business, that's not in the medical field, you need to take certain measures to protect your employee. So it would be the exact same.
I couldn't agree more. Like you said, you just want to make sure that you're fostering an environment in which your employees feel safe and feel as if you as the employer are valuing their safety. And so, again, adding that language, if it's applicable to your company, is important.
Very good. Second question. Are part-time non-exempt employees eligible for overtime? For example, if a part-time employee typically works 30 hours a week or less, but 1 week works 31 hours, would he or she be eligible for time and a half overtime pay?
Yeah, Ariel, you can back me up on this if I'm wrong, but my understanding of the FLSA is that it's over 40. So even though for her that would be over her regular schedule, it's not until she reaches that any time over 40 that she's entitled to overtime.
That's correct. That's my understanding.
Yeah, I haven't seen any cases where overtime starts to calculate for different employees, and I think that's because you want to keep it pretty clear as it's anything over 40 for everyone that's non-exempt, not, if overtime to her is 31 hours or more instead of 30. I think it's just easier to apply it that way.
Very good. And another question. Can one, by policy, forbid disparagement of the employer or the practice through an employee's personal social media account? I know you address social media, so is that something that can be forbidden in a policy? and how would one define what is negative to warrant discipline?
Arrow, do you want to take that one?
Can you ask that question one more time? I'm sorry.
Sure. Yeah, it's all right. Can a practice by policy forbid disparagement of their employer through their personal social media accounts?
Through the employee's personal account?
Right. So I think the question is, if an employee says something bad about their employer on their own personal social media, can the practice take action or have a policy that would forbid that?
I would recommend against that. Again, you want to foster an environment, a working environment in which your employees feel comfortable about taking their grievances to you directly instead of airing out the dirty laundry per se. But you can't. I would advise not trying to prohibit someone from just freely using their own platform to air out their grievances, because in looking at some of the NLRB opinions, I believe that would run afoul of some of their opinions.
And that comes up. I mean, there's been several cases on that where the employee was mad and they went on Facebook and just blasted their employer. And again, that's why our employer clients have trouble digesting that, because it's just maybe what they're saying isn't true, but they have to be allowed to. If it is true, you can't just say you can't make any disparaging remarks, because maybe the employer is acting in bad faith with some of their policies, and if you have brought that to the public's attention, technically that disparages the company because it makes them look bad, but it may not be untruthful.
Correct.
So that one's hard.
Very good. Another question. Does safety or harassment of employees continue into the parking lot? What's the boundary for the employer's responsibility?
That's a good question, mainly because earlier, we talked about with solicitation, that the parking lot isn't considered a workspace, the work site. That comes more, I think, into like a premises liability question. I have some colleagues who do that, and, whether you're required to keep them safe. Again, I think Errol would agree, you need to keep your employees as safe as you can. So I would advise that should be included as, yes, that it does extend to the parking lot.
I would agree.
Very good. I have another question. I'm not sure I understand. I'm asking for a little bit of clarification. But the question is, a fireable offense as an at-will employment situation. Let's see. I'm going to see if there's any clarification on that. I'm not sure how is a fireable offense as an at-will employment.
Are they asking what are fireable?
Yeah, I guess maybe examples of what would be a fireable offense in an at-will employment situation.
They may not like your shirt. Yeah, that's the whole thing with that. We tell people with at-will, like, they may not like your shirt. As long as it's not like a religious shirt or something that's protected, by Title VII, like.
Right.
You don't have to have any reason or no reason. That's what at-will means. Either the employee or the employer can terminate the relationship.
That's what it means, and I'll just say that as employers, you want to be responsible with firing. Although at-will is for any reason, if it's something such as your shirt, it just opens the door for litigation. If they suspect, if the employee who's let go suspects that it's some arbitrary reason, they might tack on, they might try to file some claim of discrimination and draw their own conclusion. So you just want to kind of be responsible in how you let people go and really think about it before doing so.
Yeah, even though employers have the ability to fire anyone for any reason, you still always, what we always say, document.
Correct.
Make sure that they can't, because they will. They'll always bring some other claim.
And just remember that it costs money to get out of litigation too. Right. So even if there's even if there's no viable claim, it still costs money to defend.
Right. And actually, I have just a little bit more context on this because I think the question is good. So it's actually a continuation of a question about social media. So let's say an employee puts an employer on blast on social media. Can the employer terminate the employee because they said something negative on Facebook about their employer. Is that, because it's at will, are they allowed to do that?
That's where it gets tricky. And Ariel,
Yeah.
if you
I think it gets tricky there, and you want to be careful that it's not like a retaliatory, or you want to make sure that you understand the underlying context of why they have made the comment before hauling off and firing. So, although at-will employment allows you to fire for any reason, it has to be lawful, and so you want to make sure that you've kind of investigated the underlying context of why before you fire.
And certainly if what they say is a lie, that you would be terminating them because of lying.
Correct.
Not because of necessarily posting something on Facebook. Does that make sense? So you always want to try to attach it to the conduct that's wrong, not just because of, they did something that was protected. Because they are protected in posting that information. So.
Very good. And then a follow-up question to the overtime question from before. So are hourly exempt employees eligible for overtime, even though they are exempt based on their job duties and part-time pay? So they're exempt employees who are part-time. Are they eligible for overtime?
No. It's my understanding of the question. Like, for example, I work part-time. I'm exempt because I'm a professional. But, if you're exempt, you're exempt. You're not going to be entitled to overtime.
Regardless of how many hours you're scheduled to work each week.
Right. Yeah.
Correct.
Very good. Let's see. I think we might have just gotten another question in. Hold on.
These are good questions.
That was a thank you for answering that question. So.
Okay, good.
All right.
Yeah, these are very great questions.
Yeah, great questions. And let me just see if anybody has any more before we close out. All right. I think we're good. Lauren, Ariel, thank you so much for this presentation. It was really very good. I know I learned a lot, and probably need to go back and look at our handbook here at our company too. But thank you again very much, and I want to thank everybody who attended today. We will have another webinar on a different topic in probably another 3 months. It put us probably at the end of June, so watch for that invitation. And thank you all again. And one other comment. So we will have a recording of this presentation. It'll be available on our YouTube channel. I would say probably a week from today. So probably by Thursday of next week, there will be a recording on, again, our YouTube channel. You can go to YouTube, search NCMS Plan. You'll find this video as well as recordings of all of the prior webinars that we've conducted. So. Thank you all very much for attending, and have a great afternoon.
Thank you.
Thank you.
Thank you again to all of our attendees for joining us today. This does conclude today's conference. You may now disconnect.